Hey everybody, we have some major immigration news to share with you in today's video, and it's regarding a new policy memo that was published on February 28th that has major implications for circumstances where somebody could receive a notice to appear in immigration court, an NTA, which is basically the commencement of removal proceedings, to have somebody ordered removed from the United States. This policy memo has some very major implications, and we're going to talk all about it in today's video, so make sure to stick around. Hey everybody, U.S. immigration lawyer Michael Ashuri here. And as I mentioned just a bit ago, we have some major immigration news to share with you in this video, and it's all surrounding this new policy memo that was published by USCIS on February 28th. Now, as I mentioned, this policy has to do with situations where USCIS may issue a notice to appear in immigration court. So if somebody gets an NTA, a notice to appear, it means that they have to appear in immigration court on a particular day, and it usually signifies the commencement of removal proceedings to be ordered removed from the United States. This is very significant because if somebody is ordered removed from the United States, they could face immigration bars from re-entering the US. So this is very significant. Now, in this policy memo, it covers various circumstances by which somebody could receive a notice to appear, an NTA. But I want to just focus on one of the bases that is specified in the policy memo by which somebody may receive a notice to appear. And it's right here, it's Roman numeral 6, and it says here, aliens not lawfully present in the United States or subject to other grounds of removability. And then it says, USCIS will issue an NTA where upon issuance of an unfavorable decision on a benefit request, the alien is not lawfully present in the United States. So this is extremely significant. And the best way that I can explain to you why is by presenting you with a common example. So let's say that somebody is in the United States as a visitor. Let's say as a visitor, they were granted 6 months of status to be in the United States. And let's say toward the end of that 6-month period, they come to the decision that they want to change their status. They want to apply for a change of status to change from their visitor visa to, let's just say for this example, they want to change to an E2 investor visa. And again, they'll go through the process of filing their E2 change of status application while they are in their valid visitor status. But that application for the E2 petition for a change of status will take time to process. And let's say while that E2 change of status is processing, the individual's visitor status expires. Now, let's say that E2 petition ultimately gets denied. Well, as of the date of that denial, that individual now is in the United States without valid immigration status. In the past, if somebody got a denial and they did not have an underlying immigration status, their underlying status has expired, well, again, at that point, they would begin accruing unlawful presence in the United States, and they would be required to leave the United States because if they didn't, after a certain amount of unlawful presence, they would be subject to a bar from re-entering the United States. And of course, by accruing unlawful presence, they also risk having whatever visa they originally had get revoked. Well, under this new policy, the consequences for having that E2 change of status application denied while the individual did not have any sort of underlying immigration status is far more severe, because as we just read in the policy memo, this person can now receive a notice to appear in immigration court to face removal proceedings. Now we're seeing that the USCIS policy memo is directing that there will be issuances of notices to appear in immigration court where somebody, again, could face removal proceedings. So what should somebody do in light of this policy memo? Well, first of all, when you're strategizing your immigration case and you're determining, should I do a change of status? Should I go back to my home country and apply for a visa rather than doing a change of status? You should factor in, if you're going to do a change of status, whether you're going to run out of your underlying status, whether your underlying status is going to expire during the processing time of your change of status petition. Because again, the risk of receiving a denial is now far more significant as it could result in a notice to appear. When you're planning on doing a change of status or an adjustment of status on your underlying non-immigrant status, that's tip number one, to make sure to consider the implications of getting a denial on a change of status and weighing that when deciding whether to do a change of status application or whether to do an actual visa application at a consulate abroad. Now, if you do ultimately decide to do a change of status or an adjustment of status in the United States, now the difference between a change of status and an adjustment of status is a change of status is a change from one non-immigrant status to another non-immigrant status, and an adjustment of status is essentially a change from a non-immigrant status to lawful permanent resident status. That's the difference between those two words. Now, the next suggestion is that if you are in position where you're going to be processing a change of status application or an adjustment of status application, you should make sure to have a lot of duration remaining on your underlying non-immigrant status, enough to cover the full processing time of the change of status petition or the adjustment of status application, because you want to be in position that no matter what happens with that change of status petition or that adjustment of status application, that you have underlying immigration status. So that, God forbid, in the event of a denial of either one of those applications, you're not left in the United States without any sort of status. Because it seems to be that if you do have underlying immigration status, in spite of a change of status denial or in spite of adjustment of status denial, that you will not be triggered, because again, it's stating here, USCIS will issue an NTA where upon issuance of an unfavorable decision on a benefit request, the alien is not lawfully present in the United States. So again, that second tip is that you should make sure to preserve your underlying status for the full processing time of whatever change or adjustment that you're applying for, so that in the event of the denial, you still have underlying status to not face the risk of a notice to appear. I know this was some very detailed information. I hope you gained a lot of value here. If you have any questions, feel free to put them in the comments below. As always, thank you so much for tuning into this video, and I'll see you on the next one.